in order to counter we said that the first version of harmless error is the way the court has said that you apply harmless error as you do in civil litigation, and so you are asking yourself whether
I know what that looks like, but how does that how do we reconcile that with Chenery, which acknowledges that the agency may well have many good explanations. We can conjure them.
That's right.
Please let me know if you guys can
so
hear
we're
it.
going to remand it.
I think that's right when it would be a completely different argument, when it would be a different
microwave,
standard, where there may be
microwave
some
oven.
alternative form of reasoning. Here, we know what the reasoning was. The question is just whether, had the agency looked at the extra bit of information, it would have made a difference to its bottom line. It's the 20 blank missing pages hypo that I discussed earlier.
And let me just turn back real quickly to the enforcement action question. Are those conducted before ALJs?
The civil enforcement actions, I'm
Microwave,
not sure.
can you please let me know if you can hear the
But
I'm
Supreme
wondering,
Court
does the company ever
ruling
have
hearing?
a chance to get before a judge and a jury?
I think the answer is yes, but I'm not sure about the details, because we haven't really been engaging in those with respect to the products that are at issue in these cases.
I mean, after Jarkissi, perhaps the answer is yes.
We will certainly comply with what the law requires.
Thank you, Mr. Gannon.
Justice Kavanaugh?
I understand your main argument is that the guidance here was not misleading or mistaken and gave sufficient notice. But as the discussion earlier, our discussion
I turned
earlier,
it
I
up.
think
Can you hear it better
illustrated
now?
when there is mistaken or misleading guidance in a situation where someone's trying to apply to obtain a benefit or license or something, that there's no real meaningful relief that the APA actually affords. And that raises a concern for me about what checks are there on mistaken or misleading guidance in situations where someone's applying for a benefit or applying for a license or something of that sort. Is it just the political process, public pressure?
Well, I think in that instance, the answer would be that you could send it back to the agency. The agency, because it was arbitrary or capricious for the agency to mislead and apply ultimately a different standard than the one that it told applicants it was going to apply, it would then have to it would then have to give applicants a chance to apply under the correct standard, and it would evaluate it. And so the check would be that the agency wouldn't just have to couldn't get the benefit of a bait and switch. The other side would indeed be able to respond to what the appropriate standard is.
But you said you could do that anyway.
Yes, in this instance, they can do that.
The APA is not adding any value to what you could do anyway in that circumstance, I don't think.
I think in that circumstance, it may not, to the extent that they have a stay that's tied to these particular denial orders, to the extent that this would be a remand, and the agency could just reconsider this application on with respect to the information that it includes in it, then maybe it would be a quicker decision.
I guess another possibility, you haven't said this, is that the agency on remand could conclude that the earlier guidance was correct and they should back away from their current standard. I know that's not this case, but that's the theoretically possible and hypothetical I'm raising.
As long as it was then, explaining its reversion to the previous position, right. Yes, to the extent that the agency has leeway under the statutes to go one way versus the other way, yeah. and it then explains that it is changing its position. Of course, our position here is that the agency didn't change its position at any point in time here with respect to.
I understand that. I was just exploring the contours. Thank you.
Justice Barrett?
Mr. Gannon, I have what I hope is an easy, practical question. Let's imagine that we are pretty confident, let's say we have a high degree of confidence that the agency would decide the marketing question the same way on remand on the harmless error point, but we still think that Chenery requires us to send it back. as a practical matter, then what happens? Because if we're pretty confident the agency is going to reach the same decision, is it going to take the agency a long time to reconsider these applications and do what we think they're going to do anyway?
In this instance, we're not saying it's a big burden in order to reevaluate these particular applications, as long as the court, assuming that the court is reversing the Fifth Circuit on the other things about not having to, about what studies it can ask for, that it wants real scientific evidence.
Just the marketing question.
It's just the marketing plans. We're not saying that it's a big burden on the agency in order to have to decide the applications from these two applicants and look at the marketing plans and confirm that there's nothing in there that changes its mind about the bottom line conclusion here.
So it's a pretty low stakes.
It's low stakes with respect to that practical reality, assuming that we win on the other parts of the arbitrary and capricious analysis. But we do think that it vindicates the harmless error rule that Congress put in place here. And to the extent that you think that we're not supposed to play this endless game of ping pong where applicants get shuttled back and forth and the agency gets shuttled back and forth between its own decision and the courts, you'd say that would be an idle formality. We don't need to engage in it. But you're right. I'm not saying it would be a huge burden to redecide a handful of applications. With respect to what we are saying, by definition, we think we already know what the agency is going to say.
Thank you.
Justice Jackson?
So the statute plainly requires the agency to evaluate benefits and harms. So can you just speak for a moment about why flavored e-cigarettes are more harmful than unflavored from the government's perspective?
The chief risk that FDA identified throughout here, and this was clear well before the marketing denial order here, with respect to flavors, is in the 2020 guidance, where FDA said it is concerned about the extraordinary popularity of flavored e-cigarettes with youth. Research has long shown that flavors increased youth appeal of tobacco products, and evidence accumulates further confirming that youth are particularly attracted to flavored ends products. Flavors are a strong driver for youth use. And so those are all quotations from the 2020
So that was
guidance.
in the guidance.
That's in the 2020 guidance before these applications were filed on pages 151 and 214 of the joint appendix. And the concern there is, as I said, that flavors are attracting youth into smoking when they are non-users.
Well, how
Congress
about
said that we
adults?
need to evaluate the likelihood that non-users are going to start using tobacco products. The concern would be that they're getting addicted to tobacco at a time when to nicotine, at a time when nicotine is dangerous to their developing brains and may be, sentencing them to a long life of needing to satisfy that addiction.
All right, let me ask you just one question about harmless error, because I guess I'm confused about the government's position. I took your reply brief in the sentence on page 18 where you say this court should reverse the Fifth Circuit's holding that the harmless error rule simply does not apply and remand the case so that the Fifth Circuit can apply that rule to be the government's asking us to remand the case. And from the podium here, you're saying, no, we should apply the harmless error rule. So I don't know what you're asking for.
I wouldn't expect this court in the normal case, in the first instance, to perform the harmless error analysis itself. What we're saying is that we don't think there needs to be a remand to the agency. And that's the point. So if you remand to the Fifth Circuit in order to evaluate whether it is persuaded that the test that I was discussing with Justice Kagan is satisfied here, that the estimation of the likelihood of the result would not have been any different here is sufficient.
So we don't have to make that harmless. At a minimum, you're saying we can send it to the Fifth Circuit to have them make the decision.
If you want to agree with us, I'm certainly not going to prevent you from doing that. If you want to say that since you don't normally analyze that type of question in the first instance, you want to remand that to the Fifth Circuit, the point is to correct the Fifth Circuit's legal error in saying that harmlessness isn't applicable. A harmless error analysis isn't applicable here.
Thank you.
Thank you, counsel. Mr. Heyer?
Mr. Chief Justice, and may it please the court, FDA's new longitudinal comparative efficacy requirement directly contradicts the guidance FDA provided before the submission deadline, when FDA knew that roughly 2/3 of adult ends users use flavored products. Before, FDA said, quote, no specific studies are required for an application. After, FDA denied applications for over 1 million products and over 250 applicants because they lacked a randomized controlled trial a longitudinal cohort study, or some, quote, other evidence comparing the flavored ends products at issue against tobacco flavored ends products as to cigarette reduction over time. Not a single applicant included these studies in their initial application.
Because you didn't ask.
Before, FDA said applicants were free to select a comparator tobacco product and justify their selection. After, for flavored ends, only a tobacco flavored ends product was an acceptable comparator. Before, FDA recommended single point in time studies on, quote, consumer risk perception and, quote, intentions. After, FDA concluded only longitudinal studies that track user behavior over time are robust and reliable. Before, FDA said it would make its determination based on the entire contents of the application. After, FDA admittedly did not assess anything in the applications beyond whether they contained longitudinal comparative efficacy evidence. Before, FDA said that a marketing plan was, quote, critical, necessary, and, quote, directly relevant to determining whether youth would be protected. After, FDA entirely ignored the marketing plans, determining that in its experience, no marketing restrictions were adequate. FDA's denial orders suffer from multiple flaws. FDA switched its position on what studies were required, and in so doing failed to consider applicants' reliance interests in the original instructions and less drastic alternatives. It ignored the marketing plans and ignored the notice and comment process mandated by the APA and the Food, Drug, and Cosmetic Act. The court should therefore affirm the judgment below. I welcome the court's questions.
You make quite a bit in your argument that FDA required certain kinds of studies at one point and then changed its mind. And yet I'm confused as to what these studies are. What's the difference between the long-term studies and the randomized controlled trials and the longitudinal cohort studies? What's the difference, and why is that a change in FDA's requirements?
So, Your Honor, a longitudinal study could be of any duration, and that's the core. That's our core claim here. FDA didn't define long-term as being 6 months or more, and longitudinal studies are any study that tracks users over time. The randomized control trial and longitudinal cohort studies are two types of longitudinal studies. A randomized control trial will assign the user specific products, tobacco flavored ends for one control group, whatever the subject flavored product is for another. A longitudinal cohort study has a lot of different ways to possibly design it that allow for selection of different flavors by the users, but it tracks them over time. Now, our point is what FDA said ahead of time in its guidance in the 2018 public meeting presentation is that single point in time surveys asking users of these products about their experiences, whether they would intend to use these products if they're combustible cigarette smokers, et cetera, were acceptable. Afterwards, and I point the court to page 266 of the joint appendix, FDA specifically said, based on our experience over the last 10 months after the deadline, reviewing these applications, we've decided it must now be a longitudinal study, that single point in time studies are not sufficiently robust and reliable. That flies right in the face of what FDA said ahead of time and directly contradicts it. That misled applicants, going back to my friend's comments. And I want to underscore what a massive sea change this was. And I'll use a hypothetical to explain it. If one had a tobacco flavored ends product that, let's say, theoretically led to a 50% smoking cessation rate of users, and a flavored ends product that hypothetically led to a 25% cessation rate, under the statutory standard and under the standard as FDA explained it beforehand, assuming that there was no youth usage of the flavored product, either of those products, the tobacco flavor or the flavored product would have to be approved because it would have a net benefit to public health. Under the new standard that FDA adopted by assigning a set risk value to flavored products, after the again, 10 months after the applications went in, that flavored product must now have a 51% switch rate. It must be marginally more effective over the tobacco product. It's a massive sea change, not only in the plain language of the statute, but in what FDA communicated.
So when did the applications go in? Because you set up your whole argument as a before and after kind of dynamic, and I'm trying to understand when is the before and after. You point to 2018 public meeting presentation as being before, and I guess there's some other, what is the point after, and when did your applications come in?
So the deadline that was set by FDA and by a district court was September 9th, 2020, Your Honor. So we had
September 9th, 2020. All right, so I see various things in the record where the FDA is making comments about flavors, including the one that the SG pointed to in the end of his presentation that happened before then. I see, for example, on page 88 of the joint appendix, a whole discussion by the FDA that says it is important for PMTAs for flavored products to examine the impact of flavoring on consumer perception, especially given the attractiveness of flavors to youth and young adults. So it seems like before your applications were due, FDA was making announcements about the significance of flavors.
Yes, and respondents satisfied that. They provided extensive literature reviews of studies, including consumer perception studies, about the role of flavors. What FDA never said in any of the guidance over the multiple years up to September 9th, 2020, is we're going to have this new comparative efficacy requirement. The word efficacy is not in the statute.
Nope.
And again, this case wasn't briefed or argued under Loper, but I think the previous guidance is consistent with the language of the statute, and FDA has massively changed that after the fact by rigging the weighing of the.
So we would have to agree with you that what the FDA has said here is actually something different or new than what it was saying about your need to provide scientific evidence, valid scientific evidence concerning the flavoring.
Well, it was new. There's no reference to comparative efficacy studies, and there's no evidence before the deadline, anything from FDA about the need to conduct any studies, comparative efficacy or not, for flavored products that differed from tobacco.
I mean, FDA says, look, you should think hard and you should give us materials about flavors, because that's one of the things that we're really going to be thinking about is flavors. And in your application, you talk about the role of flavors, right? That your application tries to show that if you have flavors, it's better at getting people to quit smoking, right? That's one of the points of your application. So I guess I'm not really seeing what the surprise is here or what the change is here. Like, everybody basically knows that flavors are particularly dangerous in terms of kids starting the use of smoking products. And so, you know, the countervailing benefit might be if flavors were also particularly good at getting adults to stop smoking. And that's basically what FDA told you, and it's basically what you tried to convince FDA of. And then at the end, FDA said, you haven't convinced us. You know, we think flavors are really bad in terms of youth smoking, and we don't think that you've shown us that they provide any special benefits in terms of smoking cessation. So I guess I just don't see where the gap is here.
Your Honor, this certainly wasn't called out at all, and certainly not with the level of specificity. And I would, respectfully dispute the fact that everybody knows this and everybody knows that.
Well, you know that FDA thinks that flavors. I mean, FDA has been completely upfront about this, and I think that the point, that flavors. You give people blueberry vapes. The difficulty with that, and FDA I think has tried to document this, is that blueberry vapes are very appealing to 16-year-olds, not to 40-year-olds.
I respectfully disagree, Your Honor. In fact, the literature review that respondents provided explained in detail that often the cessation journey for combustible cigarette smokers.
No, I'm not saying that you don't have a point of view on that question, but you knew what FDA's point of view on that question was that blueberry vapes are really problematic in terms of youth smoking. And you know that FDA was basically saying to you, so given that that we think that, you've got to show us otherwise, that your product, your flavored product, is going to be particularly good at getting people to stop. I mean, there's just not a lot of mystery here about what FDA was doing. You might disagree with that because you think that, in fact, the world of 40-year-olds really wants to do blueberry vaping, but you can't say that FDA hasn't told you all about what it's thinking in this respect.
Well, going back to the 2020 enforcement guidance, which is a document that my friend points to as providing notice on this, the 2020 enforcement guidance doesn't speak, and I respectfully point the court to Judge Jones' dissent from the initial panel decision on this, and also to the Biddy decision out of the 11th Circuit. What that enforcement guidance speaks to is cartridge-based flavored products, and it talks at length about the device characteristics that make those particularly attractive to youth. Respondents' products have no history, zero history of youth usage. And That's the case if we look at the National Youth Tobacco Survey data from CDC, et cetera, all this literature that was in the applications, that's the case for bottled e-liquids generally. The devices with which they are used don't have any sort of a track record of being substantially attractive to youth, and nor then do the e-liquids.
I feel as though you're arguing the merits back to me, and if I encouraged that, I apologize, because that's not what I was saying. What I was saying is that FDA has been completely upfront about what it thinks about the role of flavors here. And you knew that because you can tell it from your own application, that your application was geared to trying to convince the FDA that notwithstanding what the FDA might think about how flavored products encourage youth smoking, there was a countervailing benefit in terms of encouraging, enabling adults to quit.
The FDA doesn't claim to have reviewed, or after the fact, post hoc rationalization, FDA claims this is what you set up to prove and this is how you proved it. They say in the marketing denialers, we didn't look at anything except whether there was longitudinal comparative efficacy evidence. So I don't think they can hang their hat on that point after the fact. Had the applications been silent as that, it wouldn't have mattered. What FDA was looking for was this longitudinal comparative efficacy evidence. That's what the marketing denial orders show. That's what the technical project lead reports or reviews show as well. And so,
but isn't it your claim about notice? I mean, just picking up on what Justice Kagan said, you're claiming we didn't know we were supposed to be looking at certain things. Am I wrong about that?
What we certainly didn't have notice is that there was this requirement to show this this comparative efficacy in switching. There was no notice on that. There was.
Okay, so you don't read the 2019. I'm looking again on page 88. I'm just baffled by your argument in light of this sentence. Additionally, to provide a better understanding of the appeal of flavors to adults, FDA recommends examining adult appeal of such flavors in their decisions to initiate use, cease use of more harmful products, or dual use. So the FDA is telling you not just flavors to youth, but help us understand your argument that there's a benefit to adults by the use of flavors. Why is there a notice problem in light of the FDA saying things like this?
Because when it's speaking to things like perception, which I think is what an intent, what it's speaking to is suggestions that single point in time surveys and that can speak to that. It's not saying you must do a longitudinal study comparing tobacco flavored against flavored over time and track the users. That doesn't follow from page 88 from what Your Honor just read.
I'm sorry, I'm so totally confused by your point, because the FDA didn't say to you that a longitudinal study was necessary. It would be helpful. It said that from the beginning, repeatedly. It would be helpful if you had these, but you don't have to have it if what you're providing can give enough. And what it said is what you provided wasn't sufficient. So I'm still at a loss as to how that's a change in position.
The reason they say it's not sufficient is because of the new standard that they adopted after the fact.
There is no new standard. The standard was always the statutory standard. The statutory standard says that this is the statute speaking. This is not them. This is not a policy. This is not a guideline. This is the statute says. You have to show that the likelihood that existing users of tobacco products will stop using such products, that adults and hopefully children will stop using these products, and the likelihood that those who do not use the tobacco products will start using such products. So that's the statute speaking. Your evidence has to show that adults need these flavored products to stop using tobacco products, full tobacco products, and that youth won't start using these. And you have to weigh whether the one is going to outweigh the other. That's the statute speaking, not their guidance.
And respondents submitted the evidence that they believed FDA, they understood FDA was asking for, and that FDA said it was asking for.
Well, no, it got the evidence. What they said is just doesn't prove the point. You want us to say it does prove the point, but they never said to you what you're saying, which is it's just that this doesn't show it.
Respondents never understood because FDA never communicated that it was going to be an end-all and be-all litmus test as to whether there was this comparative efficacy evidence. And that's what ultimately happened here. And any other
But that
evidence
is because the statute makes it the litmus test.
I respectfully disagree.
You're trying to change the statute, but the statute is very clear. Tell us that your product is going to help adults stop smoking cigarettes and show us that youth is not going to start.
The statute, Your Honor, goes back to my hypothetical I gave previously, which is to show a net benefit of public health. And respondents submitted literature reviews. They submitted ample information that a lot of adults use blueberry flavor and other non-tobacco flavors, and that often the quitting journey is to move away from tobacco or menthol flavors because they don't want to be reminded of the combustible cigarettes. They want to move to these other options to stay quit, to be quit and to stay quit. And that's the type of literature they provided.
Good man.
But if the agency says that doesn't outweigh the harm to youth, we've reviewed everything, we're aware of everything. Of course they're aware of everything that's out there. It's kind of the end of it, isn't it?
Well, Your Honor,
I mean, you disagree with the statute giving that much discretion to FDA, and you disagree with FDA, to Justice Sotomayor's point, weighing of the two parts of the balance. And I understand that, but trying to figure out what the legal error is there.
the challenge here is procedural, Your Honor. It's procedural. It's a change in position. So
I understand that. I'm just making sure there's not, you agree that at the end of the day, the agency has to make a choice, and it's going to be a choice with uncertainty.
It has to make a choice, but when it changes like it did here, what that test is going to be, or its interpretation of the statute, it has an obligation to identify the fact that, to realize the fact that it's making a change and what it's communicated, to consider less drastic alternatives, such as the option to give applicants an opportunity to go and conduct those studies, which is what we're seeking here.
And I know what you're seeking here. I'm sorry to interrupt, but what exactly would be, this is the question I was asking Mr. Gannon, the relief that you're seeking in terms of what it would cause the agency to do as a real world practical matter?
So practically to have the marketing denial orders vacated and remanded as the Fifth Circuit did. And I'll point out, we don't.
That wouldn't allow you to start selling the product.
Well, because of the deferred enforcement policy, our clients are still allowed to sell the products, but that's because of FDA's policy. It's a fairly unique circumstance here. Right. I recognize that.
Yeah.
And frankly, we don't know how FDA is going to approach it on remand. We have a new administration coming in. The president-elect is on record saying, I'm going to save flavored vapes. We don't know exactly what that's going to look like. It may be that the approach the agency takes is much more aligned with the statute and looks at all the risks and benefits.
But you could reapply all those things you talk about in the political process. You could reapply, and all that could happen through that process, right? In other words, I'm trying to figure out what's different from reapplying, just reapplying, and what's different from reapplying after a vacator.
The distinction here with respect to respondents specifically is they're going to have to close their doors. If they are, this in effect is punitive for them, because reapplying, closing down, and the matter is, even though the statute calls for decisions in 180 days, FDA is taking 3 or 4 years at least to make determinations on these. They can't afford to wait that out. If these MDOs are not vacated and remanded back to the agency, they're closing their doors and they're done. This was their one shot. That's why it was so important for FDA, when it changed its position, to communicate that and give them an opportunity to meet the new standard, and that's what was denied here.
Okay.
How is your position consistent with respect to how much guidance has to be provided with the well-recognized authority of agencies to proceed on a case-by-case basis?
In this case, Your Honor, our position is that FDA made this determination that it was going to apply this litmus test, this longitudinal comparative efficacy requirement, in the abstract without the particular facts of any particular case. And that's demonstrated through the internal August 17th memorandum, which admittedly was rescinded, but then we see it copied word for word in each and every one of these technical project lead reviews that underscore the denial orders for every single applicant for flavored products. And so here, the reality is this was a forward-looking determination, prospective determination that in effect was a rule. It was setting up a new standard.
So your position is that the agency, again, at a fairly general level of abstraction, your position is that the agency has to give guidance on what's required to comply, as opposed to simply that the agency may not mislead an applicant on what's required to comply.
Well, they certainly misled here, but once the agency has spoken, as it did here, and then when it changes its position, then it certainly has an obligation to communicate that change. We think that's the lesson from this court's precedents and from the arbitrary and capricious standard that Congress has set forth in the APA itself.
So you say there's a change of position. The agency did not say originally that you did not have to have this information. I mean, I think I could appreciate a change if on day one, the agency said, do not submit this kind of information. You do not need it, as opposed to what happened here. So can you say a little bit more about the change?
Well, to your Honor's point, the agency did say you don't need to do a randomized control trial. Afterwards, that's one of the options that they're saying you do need to do. Before they said you don't need to do a 6-month, long-term study. And what have we seen so far? We've seen that the only flavored product that FDA has in fact authorized, the Enjoy menthol product, was a 6-month study.
I thought they said these might not be necessary. In other words, there could be other ways that you can satisfy the standard. That's different than saying this is irrelevant, don't submit it, we're not going to look at it, we don't care about it. That's the kind of it's not necessary that would create a conflict in the way that you're trying to describe, as opposed to saying it's not necessary because you can satisfy this in potentially other ways, right?
Your Honor, in my introduction, I think I listed through 5 or 6 ways that we believe the agency absolutely flip-flopped and it misled applicants. It said one thing and then ultimately
Let them share it.
required another. When it says no specific studies are required, which it said, slide 26 of the 2018 public meeting, clearly some specific study is required. It also said it in a letter to Biddy Vapors. We've cited in a footnote dated May 8th of 2020, just 4 months before the application deadline. Biddy wrote in and said, what comparator products do we need to use? And FDA said, we have no requirements for comparator products. After the fact, it must be a longitudinal comparative efficacy study. It can be a randomized control trial, a longitudinal cohort study, or some other evidence that tracks users over time.
Can I ask you this? The statute, go ahead.
No, go ahead.
Statute says you have to have valid scientific evidence. What if the agency had said you don't have to present any evidence? Is it your position that based on the agency's changing of its position, because at the end of the day they asked for evidence, that you would be entitled to authorization? In other words, I see certain things in the statute that appear to give people notice as to what the agency is going to look for, et cetera, et cetera. Let's hypothesize that the agency says something different than what the statute requires. Is it your position that at the end of the day, because of that change in position of the agency, you would be entitled to authorization?
If there were notice from the statute, I don't know that that would be my position, Your Honor, but certainly there's no notice from the statute that comparative efficacy studies are specifically required. Again, the word efficacy or effectiveness is not found in the statute, much less that it must be flavored products against tobacco flavor.
Thank you.
Counsel, can I ask you a question about your good faith reliance argument? So a lot of your argument turns on, well, all of your argument turns on the switch in position in the guidance. Now, let's say that I disagree with you that this switch was so clear. How much are you relying on, well, listen, we interpreted it that way and we have good faith reliance on this interpretation. It's almost kind of like a reverse Chevron deference, except we're deferring to the applicant rather than to the agency. Can you walk me through how that can possibly be?
Well, we're not saying necessarily you must defer to the applicant, Your Honor. We're saying this was in fact a flip-flop here. This was in fact a change on the factual record. I understand it's a factually driven analysis.
So you're not making any kind of argument that you relied in good faith because these guidelines could be interpreted your way?
They were, as a factual matter, they were interpreted that way. So I don't see the distinction of practicality given the facts here, I guess is what I would say.
So you're saying the only way they could be interpreted is the way that you interpreted them?
In terms of FDA saying things like no specific studies are required, yes, we interpret that to mean no specific studies are required and certainly not.
Okay, so your position is that the switch is clear and that's all we would have to decide for you to win?
Correct, Your Honor.
And just I want to return to a point the chief was making. Do you agree or disagree that the FDA didn't have to say anything? I mean, these were sub-regulatory guidance that you were relying on, but do you agree that the FDA didn't have to provide that?
If FDA had never spoken and said the deadline is September 9th, 2020, there's a statute, have at it, that would be a different scenario. And how FDA ultimately applied the statute, we may have different arguments, but here FDA did speak, and that's what then triggers the obligation to communicate the change in position.
You say,
Sorry, please, go ahead.
go ahead. Go ahead.
All right. The harmless error argument, what do we do about that? Isn't it pretty obvious what will happen on remand if we bother to require that formality with respect to the marketing plans?
It's not, Your Honor. First of all, for two reasons. One, as I noted, there's going to be a change in administration, so we don't know how the evidence is going to be reevaluated or evaluated for the first time, I should say, on remand. Secondly,
putting aside the obvious, as a legal matter, all right, the statute does have a harmless error rule in it. Now, how to reconcile that with Chenery is an interesting question. But it's there, and it has to mean something, doesn't it?
Right, and Your Honor, here, given that FDA, going back to Justice Alito's comment or questions earlier, given that there is no evidence in the record of what the contents were of the marketing plans that FDA supposedly reviewed and said that these aren't, and then ignored these, and again, that's a post hoc rationalization. FDA didn't even say these aren't any different, so we're not looking at them for efficiency purposes. But given that that would set up an unreasonable evidentiary burden on us to prove that the outcome would have necessarily been different on remand. And that's sort of the core of argument. And I think specifically here, going back to Chenery, when you have an agency determination that it's appropriate for the protection of the public health, the word appropriate suggests that the agency has a lot of power to determine, to establish that. And this is particularly a technical and scientifically driven determination that weighs strongly in favor of remand back to the agency to look at the evidence. Like Calcutt, this is a fact-intensive inquiry, not one where the court should, this court or the Fifth Circuit should step in and attempt to do the agency's job for it.
In response to Justice Barrett's question about if the agency had given no guidance and just said, there's the statute, have at it, I think your answer was that would present a different scenario. I just want to make sure you agree that the agency could do that.
Theoretically, they could. There's nothing in the Tobacco Control Act that required it.
What, theoretically,
Right.
is that a yes?
Nothing in the Tobacco Control Act required them to put out guidance or a rule. Now, this was sort of all cart before
So
the
that
horse.
is a yes.
Yes.
Do I understand? I read your briefs as being 100% a change of position argument. I mean, there are these other little things, but I guess what I'm saying, it's
Little
a change of
things.
position
I love
argument and not, there's no freestanding fair notice argument in your brief. That the fair notice idea comes into play because you're saying there was a change of position. So you were following one set of guidance when in fact they were applying another set of guidance. Am I reading you right?
That's certainly our primary argument, Your Honor. There is this DC Circuit line of case law, and I would point the court specifically to the Salzer case, which is referenced heavily in satellite broadcasting. And Salzer is interesting and somewhat analogous here because in that case, Salzer v. FCC, you had 51 applicants and they were applying for permission for radio towers or something like that. And there was a specific form that FCC wanted, and 44 of those applicants didn't include that form. And the DC Circuit looked at that, and that was only about benefits. That was about getting a license to operate these radio towers or what have you. And in that case, it was only about benefits, and the DC Circuit said, if you're going to have very specific and demanding criteria for acceptance of the application, then you have to be more specific in what you're setting out. And that has been the law at least in the DC Circuit for 60 years.
Yes, I guess what I was suggesting was that I read your brief, and whenever I read about notice in your brief, it was always connected to the change in position. And I took from your brief that that was your argument, that this was unfair because they changed position without telling us, not a kind of freestanding notice argument that didn't have anything to do with the change of position.
That's certainly our primary argument, Your Honor, but I think if I can call it a secondary argument, I think this line of case law is out there. It's been long embedded.
Did you talk about that anywhere? Because I read your brief, I didn't see that.
Yeah. Well, we cited that line of case law, I suppose, in support. Given the facts here, the agency did speak, it did take a position, so that's what we were addressing. But I think that secondary argument is there.
Justice Thomas, Justice Alito? I'm sorry.
Question. Did our decision in CalCut change harmless error analysis? Was CalCut a harmless error decision?
It was a harmless error decision, Your Honor, in requiring, in so much as it requiring remand, whether it moved the needle in terms of the existing case law, I'm not sure that I would say that it did.
But do you have any objection to do you disagree with the government's argument that the harmless error rule applies and that the question is whether the error had a substantial bearing on the ultimate rights of the parties? Is that a correct statement of the rule?
I don't think I would disagree with that, Your Honor. The point is here, we don't know what the comparison was. It's not of record.
Okay, all right, thank you.
Justice Sotomayor? Justice Kagan?
Just in its reply brief on satellite broadcasting, the government says that, well, that case was one where the DC Circuit required an agency to provide fair notice before dismissing an application as a sanction for violating a procedural rule, and that's not the circumstance we have here. I just want you to respond to that.
It can be described as the flip side of the coin. It can be described as a sanction, or it can be described as denial of a benefit. And Salzer, the reason I go to Salzer, which predates satellite broadcasting, that was absolutely a denial of a benefit. Here, it's even more, as the Fifth Circuit pointed out, even more of a sanction, even more punitive. This is closing the doors of respondents' businesses, Your Honor.
Yeah, thank you.
Justice Jackson? Thank you, counsel.
Thank you, Your Honor.
Rebuttal, Mr. Gannon?
Thank you, Mr. Chief Justice. If I could just make 3 points. First, following up on something that Justice Gorsuch asked me before about the enforcement actions that FDA has taken in this context. It hasn't with respect to these applicants, but FDA has brought civil money penalty proceedings before ALJs. And when it asks for injunctions to prevent marketing, those are suits that it has to bring in district court. Second, my friend said that there's zero history of their products being used by youth. That's a slight change from the position that they articulated in their brief, which was that at the time FDA gave this denial in 2021, that the number of people using open devices that use the liquids like the ones that they want to market were only being used by about 6.5% of youth at the time. The statistics on that are the same. 7% of youth are still using open tank systems or mod systems, according to survey results from earlier this year. That's more than 114,000 middle and high school students who are using devices that could use liquids like the ones that
And how many
respondents
adults
want to
are using those same devices?
And FDA has explained throughout that its concern there was that, yes, it had limited, it had taken enforcement action against a particular type of device in 2020. It was concerned most about cartridge devices that were most popular with youth at the time. After that, by the time of the decision here, youth had migrated to disposable devices, and FDA is legitimately concerned that youth are chasing the flavors that they want. And there's every reason to think that if they needed to use open devices that use liquids like this in order to get the flavors they want, that number would go up. FDA is legitimately concerned about that. And so that's my third point. There's no mystery here, as Justice Kagan was explaining, that FDA thought that there is an increased risk to youth. Respondents were on notice of that, and indeed common sense tells us that a flavor like Mother's Milk and Cookies is going to be disproportionately attractive to children. And respondents knew that they needed to make this comparison. They tried to show that flavors had an offsetting benefit with adults in their applications. FDA reasonably concluded that they didn't have sufficient evidence to establish that proposition. We urge the court to reverse the judgment of the Court of Appeals.
Thank you, counsel. The case is submitted.
I don't know what to say after all that. I'm not sure if it is over or not. It looks like it has. It looks like the video's ended. Let me cancel that here. I'm not a lawyer, so I can't really tell you exactly what took place. I can't tell you if it sounded like we were winning or losing. I'm not sure. I will have to have Greg go through that when he comes back on the show and talk a little bit about what took place today there at the Supreme Court. But I wanted to get home. I got home and I wanted to make sure I get this live on the show for everyone to hear. I wish there was some audio. I like to see faces and see the expressions on their faces, which kind of helps when you're trying to figure out if you're winning or losing is by looking at someone's face expressions. But we didn't get to see that. It was just audio today. Hopefully, everyone share this and get it out there so people can hear what took place today. Big day for the industry and the community. Hopefully, we got our point across to these 7 judges and something works out for us. If not, we're going to have to rely a lot on the new administration coming in with Trump and some of the appointees that are going to be taking positions in the FDA, the CDC, the health organization. So, yeah. So, hey, Michael, how's it going, buddy? That was it, Mike. Michael, that was it. There was nothing else. He just said the case has been submitted, and that was it. And it just went right offline. So I'm not sure. Like I said, I'm not a lawyer, so listening to a lot of that, I'm trying to figure out. In a few, if I remember correctly, Dale, I think Greg said sometimes it takes a couple weeks. Who knows? I mean, there's so much going to happen within the end of this month of December and then into January as well. I'm going to take a guess. I don't think we're probably going to hear anything back from the Supreme Court probably until sometime after Trump's inaugurated into office. And then I think that's going to start the ball rolling. And then that'll decide what our next, I'm assuming that'll decide what our next step is. Like I said, it started at 10 a.m. I got off work at 7 and I worked last night and got off work at 7 and hauled ass home to try to get this on here. So hopefully that helps. Like I said, I'm not a lawyer. Listening to them plead their cases and the back and forth. To me, if you want to know the truth, it almost sounded like we were getting our asses handed to us by these judges. I hope that's not what took place because I can't really tell. There's a lot of legal mumbo jumbo that I don't understand. But from what I took from it, it sounded like we were getting our asses handed to us. I think it almost sounded, I hate to be that guy, but it almost sounded like we were, everybody remember that guy that would come into class who didn't study, didn't prepare for a test. That's what it sounded like to me. I could be wrong. Like I said, I'm not a lawyer, but it sounded like we were not prepared as well as I think we should have been for this. This was a big deal for us. And I could be wrong. But again, like I said, I'm not a lawyer, but to me, it sounded like there was a lot of that when I start hearing that to me sounds like someone that wasn't prepared for oral arguments. And I don't know. Like I said, hopefully I'm wrong. I want to be wrong, but to me, it just sounded like we were the 11-year-old or no, I wouldn't even go that. To me, it sounded like we were the child in a room full of adults. And hopefully I'm wrong, like I said, but that's what it sounded to me. I don't know. What do you guys think? Did it sound like we were very prepared for this case? I know they go through the oral arguments and then they do their back and forth and fight their arguments, but not sure who the female judge was that was speaking, but it sounded like she wasn't going to take his BS. And she let him know that it was BS in a legal way without saying it was bullshit. But it almost sounded like she was calling him out and pretty much showing that he was pretty much unprepared for what was taking place. And again, I'm not a lawyer, but he sounded very, very unprepared. That's all I'm going to say. I could be wrong. did the first half go smoother? Microwave. I was, hey, James R. I didn't get to hear that part of it. Like I said, I was on the road driving back from the house, and that takes me a half an hour. Hopefully he did sound more prepared. It sounded like when they fired back on that second part there, it sounded like he was a little tongue-tied and tongue-twisted, whatever way you want to call it. Here's Michelle. Michelle's going to look at this. She's going to jump in from sunny Florida in her backyard. Of course, palm trees. It's like 85 degrees, and we're over here.
I forgot my earphones, so let me go get them real quick.
I can hear you pretty good. I don't know if you can hear me, though. Probably not.
Oh, yeah, I can hear you fine.
You coming in
Yeah.
nice and clear. You don't have to get them if you don't need them.
Okay, all right. I didn't want feedback or anything.
Oh, no, you sound perfect. Perfect.
Good.
Yeah, I don't know. What did you take from it? Did it sound, now, like I said, I'm not a lawyer. Michelle's not a lawyer.
Mm-mm.
But it sounded, that second half of it to me sounded like we were a bit unprepared.
I was really disappointed. I mean, at the moment, anyway.
Okay,
We'll see what happens.
It was not just me then.
No.
Okay. All right.
No, I'm right there with you. I don't think that, they always say that these guys won't give you an upper hand. They won't let you know what they're actually thinking. And
Right.
even though they act one way, doesn't mean that that's the way they're going to rule.
Yes. Yeah. I'm hoping that
Yeah.
he had pleaded his case enough
Yeah.
to convince her. But like I said, I know they can't use the word bullshit, but it almost sounded like she was calling him out on his bullshit. And, does it sound about right, Michelle?
Absolutely. It did. It did not sound good for us at the moment.
No. But yeah.
But one thing I never have understood is why we are not using the science,
Right.
the papers, and saying, look, this is what we have. This is the amount of people. Look at all these science. And how can they dare tell us that this does not matter?
Yeah. No,
I don't get that, but I'm not a lawyer. So
yeah, see, from what I understand from when Greg was on last time, and she pointed that out in the end part when he tried to argue a second argument, which she told him basically, did you post that? Is it part of this argument? Is it on here? And he said no. Then she just basically said, well, you got nothing. I don't want to use any bad words, but you're shit out of luck is basically what she said to him. For me, it just seemed like we knew. And again, me and Michelle are not lawyers. We're not going to be standing in front of 7 Supreme Court justices. I'm sure it's hard. I'm sure it's very scary. I don't care how long you've been a lawyer. That's the cream of the crop right there. And you better be ready. Is all I'm saying. And I think a lot of it has to do with the briefings prior to this date coming into court. And for me, it's just like, we knew what their argument was going to be. It's not like it's new to us. It's not fresh and new. We know it's going to be about kids and flavors. Those are the two things that they're going to stick to. And I think they tried to prove that point, and then also tried to prove the point that they were changing the rules here and there without notice. And I don't think she bought it, to be honest with you. And now I don't know how all the other 6 are going to look at it. But for me, what I took from whoever she was, I can't remember who it was that was speaking there in the end, I don't think she bought his bullshit. And I don't know if he was able to even sell that beat up Cadillac, for them. It just didn't sound right to me at all. That whole part of it. I was sitting here, I was trying not, you can barely see me because I was on the small screen, but I was sitting here thinking to myself, if I was in court and that was my lawyer, I'm just going to put my hands up like this and go, okay, how many years am I going in for? Because it didn't sound good. And again, like Michelle's saying, they try to hide how they feel on this case. So we don't know. She may be just kind of push some buttons and setting out a little fear out there. But for me, from the moment I jumped in to the end, I never felt like we got our point across. And I don't feel like Michelle, I didn't feel like they didn't give him an opportunity to. They didn't cut him off. They didn't stop him from speaking. None of that. I think they gave him an opportunity to prove his point, and I think he had no point.
I agree with you on that, but I was surprised that we didn't hear Chevron
Yeah.
at all that I'm aware of. I didn't hear it at all, and I kept waiting for it to be, brought up somehow, and I never heard it. So maybe I just didn't hear it.
Yeah, it might have been in the beginning. I didn't listen. I got off I was supposed to get off at 6, but then someone called in sick and it kept me an hour or later. And I was like, no. So I got in my car and I hauled ass back here and tried to get this all up. But yeah, I didn't hear it again. From what I took from that, what she was saying about trying to add the second argument, if it wasn't in the briefs, it is not going to be discussed. So I don't know if that was part of it, reason why it wasn't brought up, because it wasn't part of the brief. So that we're going to have Greg come on and help us better understand what took place, especially for myself, the first half. I wasn't able to hear the first half. So I'm going to go after I log off. I'm going to see if I can listen to the replay, hopefully get a better sense of where it went on that second half, where I came in on how it got from where, I didn't hear the first part. So I don't know what happened and how it got to where it ended. Was it weird for you how it ended? I mean, it was just like the case has been entered, boom, end.
Well, except I kept thinking that, I've heard several times that these things they have other cases. So they really only allow no more than an hour and a half.
Right.
That's what I have heard several times.
Yeah, that's what Greg brought up too. Yeah.
It was an hour and a half.
Yeah.
So I think they were looking at time constraints as well. And, maybe that was it.
A government agency that's efficient? What is wrong? What is wrong? It's boom. It's 1 hour and a half. Bam. Gavel down. End of case. Let's go.
Well, it's hurry up and wait. It's always on their time,
Well, yeah, that's what I'm saying. I'm just kind of shocked that it actually ended on the button. It was just like, yep, this is over. Boom. Gavel down. See you later.
That was it too. That was it.
Yeah, James. Yeah, we know. Greg brought it up. There's several cases, and it ends, and it was just. I don't know if I was like hearing, a little bit more. It was just gavel and done. Case has been heard, and hopefully, like I said, I'm not a lawyer. Michelle's not. I didn't go to Harvard. Michelle didn't go to Yale. So
no.
But I am jealous of Michelle's stunning background over there.
Well,
I hate you.
I have to have a quiet home at the moment, on the inside. So I had to come find another place.
Sure, you said let's torture everyone that is in 30 below snow.
Look, I even got my sunshade up.
She's afraid of the sun, guys. She doesn't want to tan any more than she has already.
No, I'd love to, but I burn, unfortunately. Now I've got medicines in me, but I used to be as brown as anything, but anyway, that's a whole other story.
Dale, yeah, I heard that too, and I just shook my head. I just shook my head, and but that's I mean, if you don't smoke and you don't vape, your knowledge on the topic or the subject is going to be very vague. But that was just, come on. I mean, nicotine, tobacco, there's two different things. There's two different things. And you would think, I'm sorry, you would think someone of that intelligence, of a Supreme Court judge, would understand there's a difference between tobacco and a nicotine.
Honestly,
you would hope.
John, I think a lot of it is, and this is just my opinion. And again, as John pointed out, I didn't go to medical school or any kind of law school.
Don't let her continue. She graduated from.
I only have a few hours of college. Okay.
Yeah, she went to Princeton. She graduated from Princeton, double major.
But I think a lot of times, they're just. I think what they're doing is they're waiting for the new administration. and the
Yeah.
new people to come in, because as one of them said, I can't remember, I think it was Scalise, but I'm not sure. One of them said, look, you can't verify that these people aren't going to come in and change anything that we put out there.
Right.
So all this may be for naught, in other words.
Yeah.
So, I think they're kind of just holding off and saying, well, we've heard you. We'll give you, something, but I don't think they want to give us a whole lot right now. That
Yeah.
was that was what I took away from it.
I
It's
did
like,
too.
well, it could go any way. So
I did too as well. I think these 7 judges completely understand what's going to happen in less than 40 days from now, and there's going to be a whole new administration. Whatever, even trying to push something through right now, and then have a whole new group of people come in. I don't think they want that. I think they're going to wait to see. This I could be wrong. And they may wait for this ruling after Trump has completely successfully. Let's remember that successfully actually have gotten his appointees into these positions, because until that moment happens, can you imagine the chaos that would take place with an administration that knows it's on its way out the door, trying to change agenda that they've been fighting for the last 12, 13 years. It would be chaos. It would be complete chaos. And supposedly all these FDA people are going to leave as soon as, Kennedy jumps into that position. So, cause they don't want to work with him. So, I mean, you could be right. You might be right. I think they might be waiting for the administration to get all their appointees through, get someone in the CDC, get someone in the FDA, get a new director, new health administrator. I think that would be the smart move for them as well, because I'm assuming they don't want this to come back, and it will come back if it does. Let's just say this, for instance. I mean, who's to say they vote in our favor, push the FDA to get these changes through, and this administration knows that they're out on their asses? Well, they don't need to do anything. They don't have to. They could just play it out.
right.
Play it out. So it maybe that's what's going on. But again, I don't think I was the only one that felt that. I hate feeling that way, and I hate being the guy to say that, because I don't want it to come back and slap me in the face. And again, I'm not a lawyer, but for me, it just really sounded like someone that, like I said, kindergarten, not kindergarten, I won't go that far back, but little 3rd, 5th, 6th grade, that didn't study for the test, didn't prepare himself, and then was just like, and I hope that's not. I hope that's not how it was in the first half of it. Hopefully, he was better prepared, or the whole crew was better prepared for this situation. And again,
If you start from the half, you pretty much saw our side of it.
Yeah.
You didn't see the other side of it.
Okay.
And because the other side was presented first,
Right.
So FDA got their 2 cents in first.
Yeah.
And there really wasn't a whole lot said at that point that I remember anyway right
Yeah.
now.
You see, that's what I'm saying. See, as someone that doesn't have that lawyer experience, you watching that first half and not seeing the pushback that you would have remembered. So to me, that tells me there was very little pushback, because you would have remembered some of it if there was any pushback from them as far as the government's case. But it seemed like they were ready for when we got up there and had the pushback. And again, they should have the pushback on us, because we're the ones fighting for those changes. So yeah, but it still seemed to me like, I don't know. I hate being that guy. Like I said, I realize that, but they do. I mean,
It leaves you speechless, doesn't it?
I mean, I hope so too. I hope that their briefs are well written. If Greg's involved, I know they are well written, because this is just these oral arguments are just a small portion of what their judgment's going to be. A lot of their judgment's going to be whatever in those briefs, and if those briefs are well written and make sense, and it sounds like to me, a few of the judges pointed out the fact that, that they didn't really make any changes. Those statutes were there. That's could be bad for us because that's our whole fight, guys. That's our whole fight. If they're saying that the FDA made that clear back in 2018, then we may have a problem. That's all I'm saying. I mean, that's how I took it. And again, Michelle, what are we not? Lawyers.
Right. Look.
No,
Thank
no,
God. Thank
no,
God.
no, I'm not. I wish I were. I'd be making some money, but I hopefully
Yeah.
for the best. And again, I think you're right. I think it's going to be I maybe early February before we even hear anything from this. I
I'm not
mean,
sure. I really don't. I don't know when we're going to hear something back.
yeah,
At
yeah,
first, I was told it wouldn't take more than a few days, and then
yeah,
I've heard it could take months. So I really don't know.
yeah, yeah. I think it would be a few days if we had a new FDA commissioner in place, a new CDC in place, uh, and all those other positions filled. I think maybe we could hear something within a few days, but knowing there's going to be complete overhaul, Trump is completely overhauling the whole system over there. So I don't think it would, even if it was not in our favor. I don't think it would be fair to put that on or to put that on an administration that is going to be bye. That's just not fair. I don't think it would I don't think it would be fair to do that until we had a new administration in place, a new FDA director, a new CDC director, a new FDA tobacco advisor, and who knows? And a matter of fact, Trump wants to, if I'm not wrong, I could be wrong on this, but Trump wants to separate the FDA from tobacco and have it as its own entity. So that's another thing that comes into play as well. So, I mean, there's so many factors that are going to be in play in here, and I don't know, Michelle. Like I said, I wish the best, and I would want things to change, and hopefully 2025 is our year.
I'm like the rest of us. I'm hoping. I just don't understand how people, adults, can actually sit there and say, "Well, we know that
Yeah,
flavors addict kids." That just is absurd to me.
yeah,
That is
and,
that I just can't even believe that an adult would attempt with that kind of
and
an
yeah,
argument.
exactly. When at least of the 7 judges, I'm gonna throw out a big I'm gonna throw a number here. At least 4 or 5 of them actually stopped at Starbucks and probably got a mocha latte this morning before they came to work.
Or their assistants got them for them. Exactly. Well, the Pentagon has, I believe someone was telling me they have 2 to 3 Starbucks in the Pentagon building itself.
Exactly. I would
So,
love I would love, oh God, if I had the power to be just to see what the top 5 orders are at those Starbucks that are inside the Pentagon. And I would just love to see what the top 5 orders are. And I'm willing to bet that house coffee, straight house coffee, may make the top 5. It might, but it won't be above mocha. It won't be
yeah,
above caramel latte. It won't be some skim milk thingy, whatever. They get complicated, those orders at Starbucks. So I'm willing to bet that house coffee is probably in the top 5 because we are talking about people that are trying to stay awake. But I'm willing to bet there's quite a few mochas in there, and I'm sure a couple other sweet little beverages. I'm sure pumpkin spice latte was up there in November sometime. So
I don't like that.
Dustin PMA, I hope he does. That's someone watching on Instagram, and I hope Greg does. I know he's a smart man, and hopefully we can get him on the show sometime this week and kind of give us a general idea what happened, because I know he was there. So that's why I didn't try to get him to come on, because I think he's sitting there
Right.
is at there. Yeah. So
Gunther is there, and Grim Green. I
Grim
know.
Green got an invite to be there as well.
Yes.
And yeah, it's too bad that they all couldn't speak. I know there's only one person that gets to speak up there and do that stuff. It's pretty basic, guys. There's no, it's not like a regular courtroom, so it's a whole different ball game. They come up, they present the state comes, or the feds, whatever you want to call them, the government comes up and pleads their case, and then we get up there, and then it's over, man.
That's
They
it.
may
One
ask,
shot.
yeah, they may ask to rebut, like she did. She asked him to rebut. He came on. He said a few more things, which were problematic. I mean, just made us look really even stupider. So I don't know, man. I got to listen to the whole thing again, Michelle. That's all I got. I had tired mind, so I did work. Like I said, I did work last night. My mind's a little foggy. I didn't have any coffee. I tried with some Mountain Dew, like at 7:30 in the morning. That wasn't too smart, but
I would have been bouncing around, man.
I'm bouncing around right now. So, and then I have to look at this beautiful sunshine behind you and all this greenery. I'm just waiting for like this beautiful peacock to land on your shoulder and just say, "Welcome to Florida."
No peacocks. Those were in Louisiana. We did have wild peacocks all over the place down there.
Nick has them in his backyard.
Yeah. I've got a video of one. He plucking away at a mall strip door, an outside mall strip door, because he saw himself. So he was wanting to go say hi, to himself.
Yeah, he's going to peacock the peacock.
Yeah. They're all over down there, but not here. Not here.
Oh yeah.
We can get the seagulls.
A seagull and an occasional alligator from time to time.
Yeah. That's all right. They're my friends.
Yeah, a friend with a lot of sharp teeth.
Yeah, they're not so bad though.
Yeah, just throw a chicken out there, they'll go chasing that thing.
That's it.
Yeah.
Doesn't take much. Just need a chicken and a long string. That's it.
Yeah, very, very long string or a very long stick.
That's what you do too when you go to catch them. You stick them. You stick a.
I don't plan on catching any crocodiles or. No, Michelle, I'm good.
What?
I'm good. They stay in their water, stay out of my pool. Everything is fine.
Yeah, but wait till you need a new pair of boots.
Oh yeah, I go to Texas for that. Get Amarillo boots. Oops, are they not selling those anymore?
I don't know. I don't live in Texas.
or what's the other one? Ostrich. I think you can't buy ostrich.
Yeah.
Can you still buy ostrich boots? I think you can.
Mm-hmm.
I think you don't go to jail for that. All right, Michelle. Thank you for jumping in there at the end.
All right.
Again, let's wish for the best, everybody out there. If you want to re-listen to it, I can actually hold on. I will put it up here for those. I think it's let's see, is it still under my thing? Supreme Court arguments. There it is, audio version. Oops, not the plus, John. There we go. There it is.
And I didn't curse too much at all in the first half of it. It was just the second half.
Well, we can cuss all we want on this show.
I cussed a lot then.
I muted my mic. I was like, I gotta mute the mic. I'm about to get angry here. And again, like I said, I mean, I don't know what the hell's going on. I don't know what half the words are on there. But there's the site. I put it on there. You can listen to the oral arguments. I don't know if it's going to be up that quickly. But let's see, October, November. See, I don't even see the 25th, 24th. I don't see ours on here. Wisconsin Bell Inc. I don't know what that is about. Yeah, just go on there. It should be calendars and listings. There we go. Supreme Court October terms. So it's not up there. December 2nd. There it is. Hold on. I will give you guys. Oh, it's a PDF. Yeah, you'll have to. You can actually. I can give you where you can read the actual oral briefs, and then I find it on that here. Let me put this will be the oral briefs if you want to read the oral briefs that we have, and then you could probably find a link on there to actually. Hopefully, they have a replay. If not, I will put a link to someone else that I know that had it live for the whole thing. I don't know if it saves it, but that's the best I can do. All right, Michelle, thank you, hon, for jumping in there, and we will see you on Wednesday.
I'll be there.
Yeah, I'll see if I can get Greg to come in and kind of on Wednesday and kind of shed some light on what took place and how he felt about the whole thing. He's always positive.
I know. That's what's great about it, you know?
Yeah. All right, Michelle. Hey, thank you everybody out there. James, Rifleman, Microwave Oven, Dale. Who else is in there? Let me get them all. I want to make sure I think. Michael Redfern. Tammy was out there. That's it. That's all. Oh, Jason Vapes. Don Locos, and him as well. Oh, Mr. Labworks jumped in. Him, Mr. Labworks. All right, Michelle. I'll see you Wednesday. Have a beautiful sunny day, Michelle.
Everybody keep their fingers crossed for us.
That's it. Keep your fingers
crossed. We don't know yet.
We don't know. We're not lawyers, just so you know that. I know. I don't think we said it enough, but Michelle and I are not lawyers. See you, Michelle.
Absolutely not.